So, Kara, Diamond Alternative Energy v. EPA, what was going on in the background of this recent Supreme Court case?
At its core, this is a Clean Air Act case. And what it's really looking at is whether or not waivers given to the state of California to have heightened regulations are permissible. But what was before the court specifically was a question of standing.
And so, then what was the specific issue that the court was asked to decide, and what did it hold in this case?
So, standing is always a threshold question for courts, right? This is the cases and controversies part of the Constitution. It's a limitation on what courts can do. And at an irreducible constitutional minimum of how we typically refer to standings elements, we talk about injury, causation, and redressability.
And you have to have all three of those things for standing.
Have to have all three, and the courts have routinely said, for example, that the causation and redressability are two sides of the same coin, and they're really to sort of check that the injury kind of carries through all the way to the remedy that's ultimately granted against the other party. This case is about the redressability element of standing.
And so, what did the court decide about redressability here?
So, this group of liquid gas producers came forward challenging the waiver that was given to California to adopt this regulation, which was also ultimately adopted by 17 other states. So, you can see that across the country, there's potentially significant depression of purchase of liquefied gas as a result of encouraging use of electronic vehicles. And what the court said is, even in instances where the regulation is really specific to the producers of vehicles, there are sometimes secondary effects, and those businesses that are affected even in a secondary manner have standing to challenge. And that's really important in a system like ours where regulations don't occur in a vacuum.
Yeah, absolutely. And so, why should people outside of this? I mean, this case sounds like it's between different kinds of fuel producers who want to sell cars in California. Why should anybody else care about the holding in this case?
This is really about, at the end of the day, opening the court doors, or maybe more importantly, keeping the court doors from being closed in scenarios where one party is injured but maybe is not directly regulated. And that's particularly true when there's economic interest involved. It only takes $1 of injury, right? So even if $1 less of gas was sold as a result of these regulations, that's enough under existing standing to allow those court doors to remain open to bring the challenge.
Well, that does sound really important and interesting, and thank you for being on the program to explain what happened in this case to our audience.
Thank you for having me.